Greetings, students. I hope that you're all in the best shape of your life. This is the fifth lecture of this certification course on law of contracts, and in this lecture I would be extensively covering the capacity to contract as mentioned under Indian Contract Act of 1872. Now, this particular topic is not as important as the last one that we discussed, that is consideration, in that not as many questions have been asked from this topic in the PCSG examination. Nonetheless, there are some topics, some subtopics that are extremely important in relation to the same. So we would be covering every such important topic in this given lecture. Without further ado, let's begin. Now, as you can see on your screen right now, Section 10 of the Contract Act requires that the parties must be competent to contract. Competence to contract is defined in Section 11, and Section 11 says that who are competent to contract, and it goes like, every person is competent to contract who is of the age of majority according to law to which he is subject, and who is of sound mind and is not disqualified from contracting by any law to which he is subject. Thus, the section declares the following persons to be incompetent to contract. Number 1, minors. Number 2, persons of unsound mind. And number 3, persons disqualified by law to which they are subject. Now, a question was asked in UPPCSG examination of 2015, and it was the most direct question that I've ever come across. The question read, minors contract is A void, B voidable, C void at the option of minor, D valid at the option of the minor. Now, we all know that minors contract according to Indian law is void. So, starting with the very first sub-aspect, that is minor. Now, what is the age of majority? Section 3 of Indian Majority Act of 1875 defines that the age of majority is generally 18, except when a guardian of a minor's person or property has been appointed by the court. In that case, it is 21. And it has been held in Dharmeshwar Kalita versus Union of India that the age of majority of a person is to be determined according to the law to which he is subject. Now, this again, it only replicates what is provided in the section 11, if you would read it. Now, nature of minors agreement. This is one of the most important topics under this broad chapter of capacity to contract. So Section 10 requires that the parties to a contract must be competent, and Section 11 declares that a minor is not competent. But neither section makes it clear whether, if a minor enters into an agreement, it would be voidable at his option or altogether void. So this controversy was only resolved by the Privy Council in their well-known pronouncement in Mohori Bibi versus Duryodhanadas Ghose. So, in this case, Sir Lord North observed that looking at Section 11, their lordships are satisfied that the Act makes it essential that all contracting parties should be competent to contract and expressly provides that a person who by reason of infancy is incompetent to contract cannot make a contract within the meaning of the Act. So the question whether a contract is void or voidable presupposes the existence of a contract within the meaning of the Act and cannot arise in the case of an infant. Now, ever since this decision, it has not been doubted that a minor's agreement is absolutely void. The ruling of the Privy Council in the Mohori Bibi case has been generally followed by the courts in India and applied both to the advantage and disadvantage of minors, as seen in the case of Mir Sarwarjan versus Fakhruddin Muhammad Chaudhary, whereby the fact was that a contract to purchase certain immovable property had been made by a guardian on behalf of a minor, and the minor sued the other party for a decree of specific performance to recover possession. His action was rejected. So the court said that it was not within the competence either of the manager of the minor estate or of the guardian of the minor to bind the minor or the minor estate by a contract for the purchase of immovable property. And it also held that as the minor was not bound by the contract, there was no mutuality, and that consequently the minor could not obtain specific performance of the contract. But then in today's society we realize that it is not possible, forget desirable, for law to adhere to the categorical declaration that a minor's agreement is always absolutely void. So the Privy Council had therefore to modify its earlier decisions, and this trend had been seen evidencing in the decision of their lordships in Sri Karakulam Subramaniam versus Kurra Subbarao. So, in this case, whereby the facts was that in order to pay off the debts of his father, which were promissory notes owing to the appellants and mortgaged to another, a minor son and his mother sold a piece of land to the appellants in satisfaction of the notes, requiring that the appellants pay off the mortgage debt. So, the appellants accordingly paid off the mortgagee and took possession. Afterwards, the minor brought an action to recover back the land. It was found as a fact that the transaction was for the benefit of the minor, and the guardian had the capacity to contract on his behalf. Lord Morton said that Section 11 and the Mohori Bibi case left no doubt that a minor cannot contract, and that if the guardian and the mother had taken no part in this transaction, it would have been void. So the contract, being for the benefit of the minor and within the power of the guardian, was held to be binding upon him. Now, following this decision, the Orissa High Court in Durga Thakurani B.J. Nijigar versus Chintamoni Swain held that endowment of property for religious purposes by guardians on behalf of minors, being within their competence, was specifically enforceable. So this is one important case law specifically related to the religious purposes. Now in Gopal Krishna Govind versus Tukaram Narayan, it has been held that if the contract is within the competence of the guardian and it is for the benefit of the minor, it is again specifically enforceable. So now that we have discussed the nature of minors agreement, let's shed some light on the effects of minors agreement. So it has been held in Padma Vithoba Chakhaya versus Muhammad Multani that a minors agreement being void, ordinarily it should be wholly devoid of all effects. If there is no contract, there should indeed be no contractual obligation on either side. Consequently, all the effects of a minors agreement must be worked out independently of any contract. Now, there are three things over here. Number one, no estoppel against minor. So suppose that a minor by misrepresenting his age induces another to contract with him. Will there be any estoppel against him, or in other words, will he be precluded from disclosing his true age in a litigation resulting from the contract? The answer is no. There is no such estoppel against the minor. The infant is not stopped from stepping up the defense of infancy. The reason is very simple. There can be no estoppel against the statute. So the policy of the law of contract is to protect persons below age from contractual liability, and naturally, the doctrine of estoppel cannot be used to defeat that policy. Thus, in Gadigappa Bhimappa Meti versus Balangoda Bhimagoda, before the Bombay High Court, Chief Justice Bowman reviewed the earlier authorities and concluded by saying that the court is of opinion that where an infant represents fraudulently or otherwise that he is of age and thereby induces another to enter into a contract with him, then in an action founded on the contract, the infant is not stopped from setting up infancy. Now, number two, no liability in contract or in tort arising out of contract. So a minors agreement is of course in principle devoid of all effects. As held in Padma Vithoba Chakhaya versus Muhammad Multani, a minor is in law incapable of giving in consent, and there being no consent, there could be no change in the character or status of the parties. So in England, it was laid down as early as 1665 in the case law of Johnson versus Spice that an infant who obtains a loan of money by falsely representing his age cannot be made to repay the amount of the loan in the form of damages for deceit. Hence, a minor cannot be held responsible for anything which would be an indirect way of enforcing his agreement. And in Jennings versus Rundle, that is a case law of 1799, whereby the defendant, an infant, had hired a horse to be ridden for a short journey and took it on a much longer journey with the result that it was injured, the court held the defendant was not liable upon the ground that the action was founded in contract and that the plaintiff could not turn what was in substance a claim in contract to one in tort. So we notice the switching over here from the nature of the substance, that is a contract, and then there is a tort. So the court held that the defendant was not liable because the very action, it was founded in the law of contract. So the plaintiff, they can never turn what was in substance a claim in contract to one in tort. So the principle, this particular principle, has been also followed in India. That is in the Calcutta High Court judgment of Hari Mohan versus Dullu Mia, whereby the court refused to hold a minor liable in tort for money lent on a bond. The court said, if the tort is directly connected with the contract and is the means of effecting it and is a parcel of the same transaction, the minor is not liable in tort. But in Burnett versus Haggis, whereby the tort was independent of the contract, the mere fact that a contract was also involved did not absolve the infant from liability. Thus, where an infant borrowed a mare for riding only, he was held liable when he lent her to one of his friends who jumped and killed her. So we notice over here, students, that the given chronology of these cases, it mentions an important idea that a contract must be independent. If there is independence between tort and contract, then there is liability, and if it is not, then not. The liability is not there. Now, coming to the third point, that is doctrine of restitution. This is a very important idea. Many topics, many subtopics are related to this given doctrine, and the very important case law that is related to this doctrine is that of Leslie Limited versus Shield. Now, under this doctrine, if an infant obtains property or goods by misrepresenting his age, he can be compelled to restore it, but only so long as the same is traceable in his possession. This is known as the equitable doctrine of restitution. Where the infant has sold the goods or converted them, he cannot be made to repay the value of the goods because that would amount to enforcing a void contract. So this doctrine of restitution, as I mentioned, is not applied where the infant has obtained cash instead of goods. The well-known authority is the case law of Leslie versus Shield. In this particular case, an infant succeeded in deceiving some moneylenders by telling them a lie about his age, and so got them to lend him £400 on the faith of his being an adult. So over here, they attempt to recover the amount of principal and interest as damages for fraud failed for the reasons explained above. They then claimed the return of the principal money under a quasi-contract as money had been received to the plaintiff's use. To this, Lord Sumner replied, further, under the Infants Relief Act of 1874, the principle which at common law relieved an infant from liability for a tort directly connected with a voidable contract, namely that it was impossible to enforce in a roundabout way an unenforceable contract, equally forbids the courts of law to allow, under the name of an implied contract or in the form of an action quasi-ex contract, a proceeding to enforce part of a contract which the statute declares to be wholly void. Now this sentence, students, it is a complex sentence. It uses a lot of sentences and there were a lot of different sentences in between. Hence I would read it again for you. Please try to get the gist of it. He makes a very important point, Lord Sumner. Further, under the Infants Relief Act of 1874, the principle which at common law relieved an infant from liability for a tort directly connected with a voidable contract, namely that it was impossible to enforce in a roundabout way an unenforceable contract, equally forbids the courts of law to allow, under the name of an implied contract or in the form of an action quasi-ex contract, a proceeding to enforce part of a contract which the statute declares to be wholly void. So he's saying that the same logic, the same idea that prohibits one thing prohibits another. And finally, the money lenders relied upon the doctrine of restitution, contending that the infant should be compellable in equity to restore the money. Rejecting this contention, however, Lord Sumner said that restitution stopped where repayment began. The money was paid over in order to be used as the defendant's own, and he has so used it and I suppose spent it. There is no question of tracing it, no possibility of restoring the very thing got by the fraud, nothing but compulsion through a personal judgment to repay an equivalent sum of his present and future resources. I think this would be nothing but enforcing a void contract. Now, this given case law is very important. I cannot stress on this enough. In fact, I feel that if you are able to memorize some aspects and some important aspects of this judgment, then it would definitely earn you some brownie points while answering the question related to the doctrine of restitution. Now, moving on to the area where minor seeks relief and whether it is compellable to restore. So in Jagannath Singh versus Lalita Prasad, where an infant invoked the aid of the court for the cancellation of his contract, the court granted the relief subject to the condition that he shall restore all benefits obtained by him under the contract or make suitable compensation to the other party. So this aspect of the doctrine of restitution found expression in section 41 of the original Specific Relief Act, that is of 1877. So this section authorized the courts to order any compensation that justice required to be paid by the party at whose instance a contract was cancelled. So the first well-known case decided under this section was our very own Mohori Bibi versus Dhurtonodas Gurze. Now in this case, the fact was that the plaintiff, a minor, mortgaged his house in favor of the defendant, a moneylender, to secure a loan of Rs 20,000. A part of this amount was actually advanced to him. While considering the proposed advance, the attorney who was acting for the moneylender received information that the plaintiff was still a minor. Subsequently, the infant commenced this action stating that he was underage when he executed the mortgage and the same should therefore be cancelled. But the relief of cancellation had to be granted as the plaintiff was entitled to it under section 39 of the Specific Relief Act, again of 1877. This is the section 31 of the Act of 1963. So, the moneylender's request over here, the only request that the moneylender made over here was that the relief should be made subject to the condition of the minor repaying to him the sum of Rs 10,500 which was advanced as part of the consideration for the mortgage. So he first relied upon section 64 of the Indian Contract Act, according to which a person who having the right to do so rescinds a voidable contract, he shall have to restore to the other party any benefit received by him under the contract. So on that note, the Privy Council held that this section applies only to voidable contracts and cannot apply to the agreement of a minor which is absolutely void. Similarly, no relief was allowed under section 65 of the Act. The essence of this section is that a party receiving any benefit under a contract shall have to restore it if the contract becomes void or is discovered to be void. Quite obviously, the Privy Council said that this section, like section 64, starts from the basis of there being an agreement or contract between competent parties and has no application to a case in which there never was and never could have been any contract. Finally, the moneylender relied on section 41 of the Specific Relief Act of 1877. And this particular section, which is the section 33 of the Act of 1963, says that on adjudging the cancellation of an instrument, the court may require the party to whom such relief is granted to make any compensation to the other which justice may require. As to this, their lordship said, this section no doubt gave a discretion to the court, but the court of first instance and subsequently the appellate court, in the exercise of such discretion, came to the conclusion that under circumstances of this case, justice did not require them to order the return by the respondent of money advanced to him with full knowledge of his infancy, and their lordships see no reason for interfering with the discretion so exercised. This again is a very important case law, student, and that's the reason why I have discussed with you so extensively. This case law Mohabibi Dhurtondas Mohabibi versus Dhurtondas Goze, and this case law of Leslie versus Shield. These two are very important case laws. Further, in the case of Manian Nadar versus Hari Kumar, there was alienation of a minor's property by a de facto guardian. The minor repudiated the sale on attaining majority. The purchaser was fully aware that the de facto guardian was incompetent to alienate. Here, it was held that the minor was not liable to restore to the purchaser benefits obtained by him. The purchaser's remedy was to proceed against the de facto guardian. The second landmark decision in this line of cases on the extent of relief available against a fraudulent minor was the decision of the Lahore High Court in Khangul versus Lakha Singh, whereby the fact was that the defendant, while still a minor by fraudulently concealing his age, contracted to sell a plot of land to the plaintiff. He received the consideration of Rs 17,500 and then refused to perform his part of the bargain. The plaintiff prayed for recovery of possession or refund of consideration. There could be no question of specific enforcement, the contract being wholly void. The only question therefore was, can a minor who has entered into a contract by false representation refuse to perform the contract and at the same time retain the benefit he may have received therefrom? So, on that note, Sir Chief Justice Shadilal noticed that Section 41 of the Specific Relief Act of 1877 would not help the plaintiff, as the language of the section no doubt shows that the jurisdiction conferred thereby is to be exercised when the minor himself invokes the aid of the court. Nor would the principle of restitution, as explained by Lord Sumner in Leslie Limited versus Shield, be of any help unless it was extended in India to cover cases of money too. So the learned Chief Justice found sufficient reason for this extension, as he said, there is no real difference between restoring the property and refunding the money, except that the property can be identified but cash cannot be traced. It must be remembered that while in India all contracts made by infants are void, there is no such general rule in England. There should therefore be a greater scope in India than in England for the application of the equitable doctrine of restitution. So referring to Section 3941 of the Specific Relief Act of 1877, His Lordship said that the doctrine of restitution is not, however, confined to cases covered by those sections. The doctrine rests upon the salutary principle that an infant cannot be allowed by a court of equity to take advantage of his own fraud. Accordingly, the learned Chief Justice ordered refund of the consideration. So, this opinion was not followed by the Allahabad High Court in another landmark judgment on the subject, namely Ajudhya Prasad versus Chandan Lal. In this case, a sum of money was borrowed by two minors under a mortgage deed. They were more than 18 but less than 21 years, but fraudulently concealed the fact that a guardian had been appointed for them. So the question was whether the lender could get a decree for the principal money or sale of mortgaged property. So in this case, Chief Justice Suleiman, who delivered the judgment of the full bench, refused to follow the enlarged view of restitution as applied by Chief Justice Shadilal in Khangul versus Lakha Singh. Here, His Lordship felt that the courts in India were probably bound by the principle of restitution as explained and restricted by Lord Sumner in Leslie Limited versus Shield, as it had already been approved by the Privy Council. In the opinion of His Lordship, any other view would be contrary to the great preponderance of authority both in England and in India, and would ignore the well-recognized distinction between the position of a minor when suing as a plaintiff and when he is being sued as a defendant. So the learned Chief Justice added that where the property is not traceable and the only way to grant compensation would be by granting a money decree against a minor, decreeing the claim would be almost tantamount to enforcing the minor's pecuniary liability under the contract, which is void. So, there is no rule of equity, justice and good conscience which entitles the court to enforce a void contract of a minor against him under the cloak of restitution. Another great judgment. These three judgments are very important, students. You must mark them down. So post these judgments, we notice the amended provisions in the Specific Relief Act of 1963. So the Law Commission of India actually preferred the view of Chief Justice Shadilal Sir, and accordingly the controversy has now been set at rest by the new Specific Relief Act of 1963. The principle of restitution is contained in section 33 of the new act. The net result of the amendment may be stated in terms of the following two propositions. Number one, where a void or voidable contract has been cancelled at the instance of a party thereto, the court may require him to restore such benefits as he has received under the contract and to make any compensation to the other party which justice may require. Number two, where a defendant successfully resists any suit on the ground that the contract, by reason of his being incompetent, is void against him, he may be required to restore the benefits, if any, obtained by him under the contract, but only to the extent to which he or his state has benefited thereby. So, subsection 1 of the above provision as noted before, incorporates the principle that he who seeks equity must do equity. The courts have the discretion to require the minor plaintiff to restore the damages, to restore the advantages he has obtained under the void agreement. A good illustration of the circumstances in which this power is to be exercised is seen in the case of Jagannath Singh versus Lalita Prasad, whereby Justice Banerjee of the Allahabad High Court said that where persons who are in fact underage induce others to purchase property from them, they are liable in equity to make restitution to the purchasers for the benefit they have obtained before they can recover possession of the property sold. But in Bhim Mandal versus Mangaram Koren, it was held that the court will not compel any restitution by a minor even when he is a plaintiff, where the other party was aware of the infancy so that he was not deceived. Now this is another important judgment related to the awareness of such infancy, whereby the party's lack of deception negates any such necessity of restitution. So in K. Mongol versus M.A. HDO on, it was held that where the other party had been unscrupulous in his dealings with the minor, the court relied on the same judgment, that is, the party was not to get restitution. So we notice that section 33(1) of Specific Relief Act of 1963 does not alter the earlier law. If the minor comes to the court as a plaintiff, he can be compelled to disgorge his gains under the agreement. Subsection 2, however, makes this distinction, makes this difference that if a minor is brought before the court as a defendant, he can be compelled to account for his portion of the money or anything else received by him as has gone to benefit him personally, such as education or training, or has resulted in an accretion to his state. Now, we are going to discuss the subtopic of beneficial contracts. So it has been seen in Raghavacharya versus Srinivasa that the following question was referred for the decision of a full bench of the Madras High Court. Whether a mortgage executed in favor of a minor who has advanced the whole of the mortgage money is enforceable by him or by any other person on his behalf. So the unanimous opinion of the full bench was that the transaction was enforceable by or on behalf of the minor. Chief Justice Wallace said that the provision of law which renders minors incompetent to bind themselves by contract was enacted in their favor and for their protection, and it would be a strange consequence of this legislation if they are going to take nothing under transfers in consideration of which they have parted with their money. So that clears out this given idea, that is beneficial contracts. So in relation to this particular subtopic, a question was asked in UPPCSG of 2003, whereby it was an assertion reasoning question, and the assertion was that minor's contract is void, and the reason given for the same was mortgage executed in favor of minor is enforceable by him. It was very much clear that although both the statements were true, the reason that is mortgage execute in favor of minor is enforceable by him This reasoning, which was given in the question, did not correspond to the assertion that his minor's contract is void. Hence, the answer was B. Further, in Thakur Das versus Kulli, on the same principle, it has been held that a minor is capable for purchasing a movable property and he may sue to recover the possession of the property purchased upon tender of the purchase money. And in K. Balakrishnan versus K. Kamalam, whereby a gift of some property under a deed executed by the mother in favor of a minor child was held to be binding on the mother. Here, the fact that the mother had reserved to herself the possession and enjoyment of the property did not destroy the effectiveness of the gift. Another important case law related to the aspect of gift. So, all these cases, they proceed on the principle that the minor has already given the full consideration to be supplied by him and there is nothing that remains to be done by him under the contract. He is now a mere promisee and praise the court for recovering the benefit stipulated. But, where the contract is still executory or the consideration is still to be supplied, the principle of Mohari Bibi case will thwart any action on the contract as we have discussed, and thus an example of what I just said is the case law of Rajrani versus Prem Adil. In this particular case, the fact was that the plaintiff was a minor and he was allotted by the defendant, a film producer, the role of an actress in a particular film. So the agreement was made with her father. The defendant subsequently allotted that role to another artist and terminated the contract with the plaintiff's father. So over here, the Bombay High Court held that neither side, that is, neither she nor her father, could have sued on the promise. Because if it was a contract with the plaintiff, she being a minor, it was nullity. If it was a contract with her father, it was void for being without consideration. So the promise of a minor girl to serve, being not enforceable against her, cannot furnish any consideration for the defendant's promise to pay her a salary. So for this principle to apply, there should be total failure of consideration. Thus, in Steinberg versus Scala Leeds Limited, where a minor purchased shares in a company and then repudiated them and also asked for refund of the partly paid purchase price, the court held that the price which he has already paid was not refundable because there was evidence that the shares were of some value. If the shares were totally worthless, they would have been a total failure of this consideration entitling the minor to refund. But he was not liable to pay further demands or calls for payments. So that brings us to another important aspect, that is contracts of marriage. So a contract for the marriage of a minor is also prima facie for his or her benefit. So it is customary amongst most of the communities in India for parents to arrange marriages between their minor children, and the law has to adapt itself to the habits and customs of the people. So it has therefore become well established in Abdul Razak versus Muhammad Hussain, among many other cases, that while the contract of marriage could be enforced against the other contracting party at the instance of the minor, it cannot be enforced against the minor. And where the agreement for marriage of a minor involves statutory violation, for example, the Hindu Marriage Act of 1955, under this the age of the girl has to be 18 years. In such a scenario, the agreement is likely to be avoided. For example, in Tulsi Ram versus Roopchand, on the date of engagement, the girl was not of 18 years, but on the date for marriage, she would have completed 18 years. Over here, the agreement was held to be valid. The other party ran away from the agreement and the court thus allowed her compensation of Rs 27,000 for mental pain and suffering, lowering of esteem in society, and amount spent on engagement ceremony. And now students, we are going to discuss contracts of apprenticeship. So the contracts of apprenticeship is another species of contracts which are for the benefit of minors. The Indian Apprentices Act of 1850 provides for contracts in the nature of contracts of service which are binding on minors. In English law, contracts of service and apprenticeship are put on the same footing and in the same category as contracts for necessaries. And a well-known English case law on the subject is that of Roberts versus Gray. Here, the fact was that the defendant, an infant, agreed with the plaintiff, a noted billiards player, to join him in the billiards playing tour of the world. The plaintiff spent time and money in making arrangement for billiards matches, but the defendant repudiated the contract. So over here, the plaintiff succeeded in recovering damages for the breach of the contract. The contract was held to be won for necessaries, as it was for the infant's good teaching or instruction whereby he may profit afterwards. Further, it has been suggested by Justice Desai of the Bombay High Court in Rajrani vs. Prem Adesso that though according to English law, the minor would be liable in the case of a contract of service where the contract was for his benefit, it is clear that under section 11, the minor's contract being void, the minor would not be held liable. Now, as we discuss the contract of apprenticeship and the contracts of marriage, the contracts which are known as beneficial contracts, we must clarify at this very moment that the contracts which are trade contracts, they are not included in the category of beneficial contracts. And an important illustration of the same is the case law of Cowan versus Neild, whereby a miner was carrying on business as a hay and straw merchant. He received a check from the plaintiff for the supply of clover and hay. He delivered the clover, which was rejected as bad, and failed to deliver hay. The plaintiff's action for recovering back the amount of the check failed. Over here, Justice Fillmore observed that in a general sense, contracts which can be brought within certain categories and are also for the benefit of the infant can be supported. A trading contract does not come within any of these categories, and the only contract of an infant which can be enforced is the one which relates to the infant's person, as contracts by which he provides himself with clothes or food or lodging, or contracts of marriage, apprenticeship and service. So it must be cleared out that trade contracts, they are not included in the category of beneficial contracts. So coming to the option to retire from beneficial contracts on majority, we notice that a minor will have the option of retiring from a contract of beneficial nature on attaining majority, provided that he exercises the option within a reasonable time. So there have been a lot of case laws on the same topic, and in John Edwards and Henry Isaacs versus Robert Broodnell Cartel, where a minor in pursuance of a marriage settled his after acquired property, and after attaining majority he received a large sum of money under the will of his father, which came under the settlement, and therefore he attempted to repudiate the settlement. Here the House of Lords held that the repudiation coming 5 years after majority was too late. Now, speaking of ratification under the same category, in Nazir Ahmad versus Jimandas, it was held that a person cannot, on attaining majority, ratify an agreement made by him during his minority, since the consideration which passed under the earlier contract cannot be implied into the contract into which the minor enters on attaining majority. So we notice over here that if it is necessary, a fresh contract should be made on attaining majority, and a new contract will also require fresh consideration. So we notice that consideration is an important aspect. And in Anant Rai versus Bhagwan Rai, where a person after attaining majority had not only ratified but also paid the debt incurred by him during minority, he could not afterwards recover it back. In the view of the Allahabad High Court, such a debt is only void and not unlawful. Now, coming to section 68, which is liability for necessaries. It provides for the liability for necessaries supplied to persons incompetent to contract. So section 68 says that claim for necessaries supplied to a person incapable of contracting or on his account. So if a person incapable of entering into a contract, or anyone whom he is legally bound to support, is supplied by another person with necessaries suited to his condition in life, the person who has furnished such supplies and is entitled to be reimbursed from the property of such incapable person. This section, student, is very important because it is related to section 10, 11 and 12 of Indian Contract Act of 1872, and any question arising from any of these sections can directly be related to this section as well. So the illustration of section 68 are as follows. Number A, supplies B a lunatic with necessaries suitable to his life. A is entitled to be reimbursed from B's property. B, A supplies the wife and children of B a lunatic with necessaries suitable to their condition in life, A is entitled to be reimbursed from B's property. Now, I'm going to talk about something interesting over here. In UPPCJ 2015, a mains question, that is question 10B, said A supplies B, who is a lunatic, with necessaries suitable to his condition in life. Is A entitled to be reimbursed from B's property? So does this ring a bell? Because exactly same question. The present problem is a replica of illustration B of section 68. And thus A in this problem is entitled to be reimbursed from B's property. Now, what is the meaning of necessaries? The liability is only for necessaries, but there is no definition of the term necessaries in the Act. We may consequently turn to judicial decisions to determine its precise import. So an illustrative statement of the meaning of the term is to be found in the case law of Chappie versus Cooper, where the court observed that things necessary are those without which an individual cannot reasonably exist. In the first place, food, lodging, and the like. About these there is no doubt, again, as the proper cultivation of the mind is as expedient as the support of the body, instruction in art or trade or intellectual, moral and religious education may be necessary too. Then, the classes being established, the subject and extent of the contract may vary according to the state and condition of the infant himself. His clothes may be fine or coarse according to his rank. His education may vary according to his station he is to fill. And the medicines will depend on the illness with which he is afflicted and the extent of his probable means when of full age. So, in all these cases, it must be first made out, however, that the class itself is one in which the things furnished are essential to the existence, number one, and of reasonable advantage and comfort of the infant contractor, number two. Thus, articles of mere luxury are always excluded, though luxurious articles of utility are in some cases allowed. Thus, it has also been held in Kuan Lal Darway Singh versus Surajmal Makhan Lal that what is necessary is a relative fact to be determined with reference to the fortune and circumstances of the particular minor. Articles, therefore, that to one person might be conveniences or matters of taste may, in the case of another, be considered necessaries, where the usage of society renders them proper for a person in the rank of life in which the infant moves. So the infant's need of things may also sometimes depend upon the peculiar circumstances under which they are purchased and the uses to which they are put. And it has been held in Bechu Singh versus Baldev Prasad that the debt incurred for performing the funeral obsequies of the father of a minor is necessary. Further, in Kedarnath versus Ajudhya Prasad, it was held where a minor was involved in a litigation threatening his property or liberty, expenses reasonably incurred on his defense were to be recovered from his estate. And in Nash versus Inman, to render an infant's state liable for necessaries, it has been held, two conditions must be satisfied. Number one, the contract must be for goods reasonably necessary to support his for his support in his station in life. Number one, the contract must be for goods reasonably necessary for his support in his station in life. And number two, he must not have had already a sufficient supply of these necessaries. The supplier has to prove not only that the goods supplied were suitable to his condition in life of the infant, but also that he was not sufficiently supplied with the goods of that class. Thus, in this case, where an undergraduate in the Cambridge University who was amply supplied with the proper clothes according to his position was supplied by the plaintiff with a number of dresses including 11 fancy waistcoats, the price was held to be irrecoverable. Now let's talk about the nature of liability in such cases. So there are two theories relating to the liability of a minor state for necessaries. According to one of the theories, the liability does not depend upon the minor's consent. It arises because the necessaries have been supplied to him and is therefore quasi-contractual in nature. And the best statement of this theory is that of learned Judge Fletcher Moulton in the case of Nash versus Inman. Here, an infant like a lunatic, it was held that an infant like a lunatic is incapable of making a contract of purchase in strict sense of the word. But if a man satisfies the needs of the infant or lunatic by supplying to him necessaries, the law will imply an obligation to repay him for the services so rendered, and will enforce the obligation against the state of the infant or lunatic. The consequence is that the basis of the action is hardly contract. The real foundation is an obligation which the law imposes on the infant to make a fair payment in respect of the needs satisfied. Now in India, the subject has been dealt with in the chapter on certain relations resembling to those created by contract. So that is the chapter of quasi-contract, as we know. Then the chapter provides for obligations of quasi-contractual nature, like I just said. Further, the liability is not personal but is only that of the minor state. So it has a very little contractual element, if we notice. But the other view of the liability in England is that it is contractual. An infant, according to this second theory, is not absolutely destitute of contractual capacity. A contract for necessaries is just one of those categories of contracts which an infant is permitted to make. Now that we have thoroughly covered the idea related to minors in the category of capacity to contract, we would be switching attention towards persons of unsound mind. So, under English law, we notice that a person of unsound mind is competent to contract, although he may avoid his contract if he satisfies the court that he was incapable of understanding the contract and the other party knew it. So the contract is voidable at his option. It becomes binding on him only if he affirms it. Thus, in Imperial Loan Company versus Stone, Lord Esher said that a lunatic, and we must notice that now such a person is known as mentally disordered. Lord Esher said that a lunatic can only set aside a contract entered into with a person of sound mind in the following circumstances. So, when a person enters into a contract and afterwards alleges that he was so insane at the time that he did not know what he was doing and proves the allegation, the contract is as binding on him in every respect, whether it is executory or executed, as if he had been sane when he made it, unless he can prove further that the person with whom he contracted knew him to be so insane as not to be capable of understanding what it was about. And it has been held in Mayhews versus Baxter that the possession of a drunken person is also the same. If he makes a contract while drunk, he may, when sober, elect to avoid the contract or to affirm it. As regards the general effect of mental incapacity on the contractual competence of a person, Halsbury's Laws of England states the following: there must be a free and full consent to bind persons in contract. Consent is an act of reason and of volition or of choice, and it is on the ground that there is a want of rational and deliberate consent that the contracts of mentally disordered persons may be invalidated. A valid contract cannot be made by a person suffering from such incapacity of mind as not to understand the nature of what he is doing. But we must remember, students, the position in India is starkly different, because in India, the agreement of a person of unsound mind is like that of minor, absolutely void. So section 12 says, what is a sound mind for the purposes of contracting? A person is said to be of sound mind for the purposes of making a contract if at the time when he makes it, he is capable of understanding it and of forming a rational judgment as to its effect upon his interests. A person who is usually of unsound mind but occasionally of sound mind may make a contract when he is of sound mind, and a person who is usually of sound mind but occasionally of unsound mind may not make a contract when he is of unsound mind. So there are two illustrations attached to this. Number one, a patient in a lunatic asylum who is at intervals of sound mind may contract during those intervals. Number B, A sane man who is delirious from fever or who is so drunk that he cannot understand the terms of a contract or form a rational judgment as to its effect on his interests cannot contract whilst such delirium or drunkenness lasts. So, lastly, we are going to talk about disability at the time of agreement. We notice that in Nilima Ghosh versus Harjeet Kaur, it was held that for the purpose of declaring an agreement to be void, what is relevant is that the person in question was suffering from a disability on the date of execution of the agreement. Thus, the report of the medical unfitness of the year 1989, in this case, being much later in point of time, was held to have no bearing on the agreements entered into the years 1985 and 1987 respectively. So an illustration of the same point is the decision of the Patna High Court in Inderjeet versus Parmeshwardhari Singh, whereby a property worth about rupees 25,000 was agreed to be sold by a person for rupees 7,000 only. His mother proved that he was a congenital idiot, incapable of understanding the transaction, and that he mostly wandered about. Holding the sale to be void, Justice Sinha explained the effect of section 12 in the following passage. According to this section, therefore, the person entering into the contract must be a person who understands what he is doing and is able to form a rational judgment as to whether what he is about to do to his interest or not. The crucial point, therefore, is to find out whether he is entering into the contract after he has understood it and has decided to enter into the contract after forming a rational judgment in regard to his interest. It does not necessarily mean that a man must be suffering from lunacy to disable him from entering into a contract. A person may, to all appearances, behave in a normal fashion, but at the same time he may be incapable of forming a judgment of his own as to whether the act he is about to do is to his interest or not. In the present case, he was incapable of exercising his own judgment. So that was very well explained by Justice Sinha in this given case, and an illustration B appended to section 12 clearly shows that a drunken person is in the same category as a person of unsound mind. Now in Chacko versus Mahadevan, whereby a sale deed of property was executed at a time when the transferor was suffering from alcoholic psychosis, which was proved by medical certificate, a very valuable land was sold for a paltry amount. The sale deed in this case was ordered by the Supreme Court to be set aside. The court said that the unsoundness of mind is a finding of fact. There could be no interference in second appeal. And in the case of Asfaq Qureshi versus Aisha Qureshi or Nivedita Yadav, a marriage between a Hindu girl and a Muslim man was declared to be no marriage at all when the evidence showed that the girl was under intoxication at the material time and was not conscious of the ongoing conversion and nikah ceremony. She also proved that she had not lived with the man even for a single day. Registration of the marriage under the Hindu Marriage Act 1955 was also illegal. The family court was thus held to be competent to declare the status of the parties and declare the marriage to be void. So students, that sums up the 5th lecture of this certification course on law of contracts, in which I have discussed with you capacity to contract as dealt in the Indian Contract Act of 1872. I hope that it proved to be useful to you. Please go through the PPT and keep on revising the case laws, as there are a lot of case laws and there are going to be a lot of case laws in the coming lectures too. Thank you. Till we see each other again.